After a 2-month break, I'm standing here in front of the last remains of the Göttingen courthouse. As you can see, not much has been left. One has to take the goings-on with gallows humour. This hearing going tediously slow required a bit of graphic realism for the eye. Reiner has now been in prison for 16 months. Overall, it's been a pretty farcical trial to date. So what happened? Lawyer Katja Woermer continued her plea, supported by the chat records among the plaintiffs, who portray themselves as victims, but seem to be the very perpetrators in this crime story. However, the statements and tone of plaintiff Justus Hoffmann's statements largely corresponds to this backdrop. Money, 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 yo digger, I'll ruin ya. Can't we do that? Oh no. Can't we photograph garbage cans? Oh yes, we'll call the police right away. Back to the introduction. Even to Viviane Fischer's nose, it seemed to smell a bit fishy, since one couldn't sell that to the crowd. So Justus reacted defiantly, saying, "The resistance." "I don't give a damn," he blurts out later. "There are truly juicier schnitzels on my plate. Do you have a brains digger, yo-yo?" A surprise was dropped in the form of a new civil legal complaint of an prosecution against Dr. Reiner Füllmich. The crime story continues. Good morning, Arne Schmitt.
Good morning.
What do you expect after such a long break?
Yes, riveting stuff. I don't know what will happen today. It can be anything. Who knows if the judge or whoever is still sick? What happens? What does the court today, given the current situation? And then finally, the new thing with his candidacy for elections. Andrea has a little more to say about that.
Speaking of election, Ms. Henning, I assume you haven't had a break for the last 2 months. How come that someone who is so critical of the system and sits incarcerated by it stands in the federal elections?
Well, first of all, he is really known as a Foundation Party activist. Thus, he stands for democratic values. He was coerced to learn by himself how some things are willfully handled now and how Germany has massively changed in terms of legislation and the implementation of its justice. Especially now because of his experience with this long pre-trial incarceration and the not-so-justifiable long-winded negotiations, it has become important to him actively involve himself politically. All the futile talk and complaining leading nowhere. So someone has to get up and say, "I'm doing something about it now."
How does the candidacy work out during detention?
Yes, at the moment it is difficult because both the court and the prison actually refuse the communication between the election team and the candidate. However, any right to maintain communication with him outside of the normal visiting hours is denied. The visiting hours are only a paltry 3 hours in total. Of course, that is for family and friends. And so it's basically a matter of good fortune that I have known him for years, and the counsel for the defense, Ms. Katja Woermer, of course, can communicate many things between us. But it's not really a democratic process for this election campaign.
You can't call it that at the moment. Is he even known in Wuppertal?
Well, we're just working on making him known there. And we have the exciting story that Haldenwang, the former president of the Federal Security Service, has also appeared there as a candidate. And that he is, so to speak, facing Reiner as his direct opponent.
Has he already noticed his direct opponent or commented him in some way?
Let's put it this way. No comments as of yet. Also, the local media, whether newspaper, radio, or television, keep a total silence about Reiner Füllmich. I called Radio Wuppertal the other day, but they actually decided to completely stonewall Dr. Reiner Füllmich.
All right. Well, thank you very much. Then I wish you good luck. Good morning, Dr. Christidis, Professor Dr. Christidis.
Good morning.
Yes, I can see you haven't rested for the last 2 months. I assume you went back to the files, Mrs. Christidis. I take it there are news about criminal complaints. Why and against whom?
I have filed criminal complaints against lower court Justice Moog and higher court judges Schindler and colleagues. Also against the lay judges and the 2 state prosecutors, Mr. John and Mr. Recher, because I believe to have found evidence for perjury and a cover-up of crime in the office. I've cleared up one mistake in my deposition. Namely, I assumed that the prosecutor John lied by claiming that Ms. Fischer's case was to be thrown out, since she had already repaid the money before the indictment, and because her husband provided evidence that he could have repaid the sums at any time. I have always assumed this to be that case, based on the criminal complaint against Dr. Füllmich. However, there was actually another criminal report that actually took place after the payment of the indictment. I corrected that. And besides, Ms. Fischer did exactly the same thing as Dr. Füllmich. She claims it was a fake loan. If she says it was a fake loan, I can't confirm. If it was the case, the money should first be provided in a trusted creditorial way. This is precisely why proper repayment contracts were made. That was exactly the point, and it is now presented differently, which annoys me no end. The money was used privately by both parties. Ms. Fischer clearly stated in one of her emails that she needed it for her health insurance and so on, and that she couldn't return it at the time. This email is on record. She also said she needed to repay all the loans over 3 months period. It's clear she couldn't pay it back immediately. She repaid it in 7 installments between mid-August to October 21st. And she didn't feed the money back through her own financial means, but she got 50,000 euros from a friend that she transferred via 2 tranches in August, and then she withdrew copyright money from the account and fed it back in small tranches. All of this was not taken into account, especially given what the Supreme Court of Braunschweig stated. It would have required proper contracts for Dr. Füllmich to transfer the money to his office, furnishing the wage packets of his employees. Also, for 2 years, Mrs. Viviane Fischer had 952 euros transferred per month to herself. No contracts exist for this money, and there are also no contracts for the film production, for the IT people, and so on. So why this measure with 2 scales?
Assume that Mrs. Fischer made use of the release from prosecution as he was able to do damage limitation, as the court argued. However, Reiner Füllmich was prevented from doing this.
So first of all, Dr. Füllmich was not able to address everything so quickly. But on the other hand, there were these loan contracts, as I said. These were not trustee contracts. That had been taken into account beforehand. And the court does not want to acknowledge this. And I really think that's incredible.
Good morning, Mrs. Woermer, Mr. Simon.
Good morning.
Yes, since January 31st, the 2-month interruption has now ended. The judge seems to have recovered. First of all, Mrs. Woermer, how is your client doing?
Yes, well, of course it doesn't get any better with the duration of the investigation. Last week, there was another incident that a prisoner almost attacked him. There must have been someone in custody on his corridor who was connected to a knife incident or who likes to stab people and had a record of stabbing people. That sort of stuff can happen. There are some people like that in custody. This prisoner has been removed now. No doubt this increased the traumatization of my client. So he's suffered some flashbacks given the constant fear of being attacked again. But more on that later. We're a little pressured by time now.
However, he's had some restrictions removed now, is that correct?
Exactly. He's had some restrictions removed so that he can now talk to the prisoners of his corridor between lockdowns, as well as walking together in the courtyard. However, only with the prisoners of his own corridor. But, oh, the downside, he had his private phone time reduced again. So it's the constant give and take of a system which loves playing with favors and does not provide a full lifting of restrictions.
Do you think that the work of the human rights organization United for Freedom has paid off to some extent?
I don't know. But let's see. I think they also wanted to send observers to the trial, politicians from Poland, either this or next week. And to what extent the complaint that was written by them has already been submitted, I don't know. It was in the making recently. But we are also in contact with this working group for unjustified imprisonment by the UN. There is also an application that has been filled out. There are contacts. So there are now some things that are also going on behind the scenes at the moment.
Thank you, and one more question. Has there finally been a complaint against Mr. Templin been filed, or is it already underway?
Yes, that's a bit difficult because the insolvency procedure has been opened over the assets of Reiner Füllmich. So, the insolvency administrator has to be included in the decision process. But there will also be news at this point, which I will give during the session.
Who of you is pleading today? Mr. Simon, is it you today?
Yes, I don't intend to interrupt my colleague Miss Woermer today, as she had stopped in the middle of proceedings last time and is now continuing from this point onward today. I wish you a good start.
Yes, if I could get a few feedbacks. Mrs. Woermer has already pleaded for a good 3 hours. What got stuck? Any highlights?
Yes, a remarkable thing was the peculiar attitude of the former petitioner Justus Hoffmann towards the donors. It was already very frighteningly clear when he said, "Why do I care about what any donors want?"
What context was that in?
The context was a chat between Viviane Fischer and Justus Hoffmann, and in which Viviane, surprisingly, found out how much money went to Marcel Templin, and whether it would then be available to the committee. Justus Hoffmann said, "No, why should it?" And in that sense, she also said, "Wow, the money has to go to the committee." Yes. And then he said, "What do I care about the interests of the donors?" That was very clear.
I think I'm a little emotional right now, you know? I think the theatrics feel like a C-movie. In my opinion, this chat between Viviane Fischer and Justus Hoffmann, when I hear something like that, as it's all proven, isn't it? A completely different set of people should be accused here. When I hear how they talk about the money, and yes, you can fiddle it this or that way, and then it's his schnitzel on the plate, or whatever gibberish, supposedly from Justus Hoffmann. What is actually being played here? I have to get a little emotional, right? We really want these chats to go public. This should have already been public before Christmas. It has to be made public, because there have to be different people in front of the court, not Reiner Füllmich. He's got to be set free. That's what it really looks like.
I assumed that exactly these things had probably been mentioned as evidence in the petitions, only if they had been allowed to be read and heard. But that is not the case.
How did you perceive the pleadings? Did it bring new insights for you?
One is completely flattened by it. If you don't follow it regularly and only attend sporadically, I must say it was good and clear. It fits everything.
What did you think was good?
What did I think was good? Yes, it's just very clear and soberly listed the facts again. And anyone who has a semi-normal sense of justice can just say that something is completely fabricated and is being stuck on him. It's so clear.
Hello, Mr. Simon. The beginning of the pleading by your colleague requested to bring a civil legal case against some of the plaintiffs. That fueled the complaint against your client, Dr. Füllmich. Did I understand correctly that Marcel Templin has the legal right to manage the money of the sale of Dr. Füllmich's own house, despite there being no legal grounds for that?
Yes, you understood that correctly. As I said clearly, there's a political conspiracy going on here. The participants are strangely always the same. The question is, why is that? Why aren't there different lawyers who are working here? Maybe it's just a practical reason. As I said, we will clarify everything in the course of the proceeding.
Does the civil legal complaint against Füllmich have anything to do with the criminal proceeding, or is it completely different?
No, it's completely different. Why? It is because the insolvency proceedings should take precedence. Those proceedings will clarify the basis for a claim or not. The next issue was that the civil legal complaint, which has now been initiated, has its purpose in making clarifying points that are not possible to resolve in the criminal proceeding. Ms. Woermer also asked to suspend proceedings until these points have been clarified. The court ruled against that, as they are entitled to. It can decide whether it will ponder the civil legal question according to its own informations that play a role here in this proceeding, both with regard to company and contract law. Or it can suspend the proceedings. That is entirely up to the court. So if this court assumes that the civil legal questions and the company law issues are to be evaluated criminally, and the civil court assumes that there was no civil legal possibility to construct a criminal complaint here, then we have two different proceedings and two different decisions, and that should actually be avoided. But obviously they are not interested in it, or already know what the outcome of the civil legal proceedings would look like.
It was very long and exhausting, but very interesting with a lot of new information. So the play of the state prosecutor bothered me the most, since it simply did not show any initiative. Katja Woermer read out so many incriminating things that criminal proceedings would actually be necessary. But the state prosecutor did nothing. Strange, isn't it?
Yes, what can I say? I am still upset about this court. From the plea of the main defender, Ms. Woermer, it turned out that there is an incredible scandal brewing here. In my opinion, there is a massive breach of law, and the criminal complaints by lawyer Reiner, Füllmich, and Katja Woermer totally ignored. This is, in my opinion, a violation of the law, i.e., a crime, and that the public prosecutor's office has filed a false complaint with many errors that are still there, and the court has not taken any action against it. Yes, and I do not have the impression that a fair trial is taking place here.
A nice state theatre at taxpayers' expense.
Yes, how did you come up with that?
I have been living here for the last 5 years.
Any reaction that you would like to share?
Any reaction? Yes, I think the whole thing is now a total farce. I have to be honest. I mean, if you heard everything that Katja Woermer read out today, then I don't know why they are continuing here. I don't know why they bother to continue here. So we'll see what's going on here. Someone wants to have money urgently for doing nothing, and the only thing that should be done is to convict the person who stole this money. So I don't understand what's going on here.
What is your takeaway from this long plea?
Well, we were told about this chat today. There was a chat between Viviane Fischer and Justus Hoffmann. This made it very clear that Justus Hoffmann expected that Mr. Füllmich to go to jail. A lot of lies and the severe injustice was being revealed today. You can't really make it up. Actually, Justus Hoffmann should be in the dock instead of Reiner Füllmich. That's my opinion.
And also other information that he gives of himself. Like, for example, that he'd be chasing Reiner Füllmich's tail, which he wrote in a denunciation portal Hoffmann belongs to. He was so close to chasing Reiner that he should be able to smell his lunch. He also said about Dagmar Hess, a former lawyer of Reiner Füllmich, that she was so crazy and so in love with Reiner that she knew how long his penis was and that it would taste like vanilla. This shows how obscene this guy really is. And such people are taken seriously in this court. You can't take this charade seriously at all.
Yes, for me today 2 things were particularly enlightening. So in general it was a highly interesting day. I have great respect for the lawyer Katja Woermer, who pleaded for hours, and I have to highly acknowledge that. And particularly enlightening for me was the fact coming from the chat between Dr. Justus Hoffmann and Viviane Fischer that he seems to be completely characterless after what he wrote there. And Viviane Fischer still showed a little semblance of character and obviously also a feeling of guilt in this chat. I don't know when that was exactly, but that was a long time ago. Dr. Füllmich was not yet arrested. Viviane Fischer was already aware that this house sale didn't unfold correctly. That was one thing. And the other thing that I found very interesting was that the note from Professor Martin Schwab made it clear why he wrote that he definitely didn't want to get involved in the disloyalty of these 3 attorneys called Hoffmann. After all, these 3 attorneys were his doctorate students of law. So he doesn't want to get involved in any issues of disloyalty regarding these three. So, he stated that in this email that he wasn't actually aware of that before. So that became very clear today, and I must say lawyer Woermer's evaluations today were excellent.
It looks we are in an emergency situation right now. It's really an emergency because they don't want to hear it. And I said again that there are 2 serious cases of disloyalty with a tariff of at least 6 months in prison. But nothing moves.
He said that again. He said that again at the end.
The judge also said in the trial that the accused will have to expect a severe sentence and nothing can be done about it. He says that the risk of escape is because of the expected severe prison sentence. And then we have now approved the second indictment. That's why I just read it all again purely preventively as far as the monthly payments are concerned. I had first considered whether I should leave it out because it has nothing to do with the current procedure. But then it may be combined with the current ongoing procedure. Otherwise we may have to wait for at least another half a year.
I honestly suspect that the second petition will now be referred back to the same judges, to the same chamber that took the decision for rejection in the first place. They do it deliberately to keep him in for another full-blown prosecution and its set of hearings. This shows me that another trick has been played. At first they reject, and then it is passed higher up for assessment, which takes another year, and then it returns back to the same judges. Whoever does not think this to have method, I don't know, no idea.
I think he contradicted the connection. He said last time that we can prepare ourselves for the second indictment.
Let's wait and see how long this contradiction will last.
Yes, exactly. And it would be nonsensical to hand it over to another chamber because they have to work it out again. The file now has 11 or 12 volumes or even more. I had now again this problem that in the indictment there was suddenly a volume 4 of the criminal record and we only knew the defense and the accused up to volume 3. So we didn't have a complete view of the files anyway. And that is directly a violation of legal procedure.
To pick up the audience who may not be able to understand your inference yet, how did the judge justify his ruling?
Well, the reason for a warning was my unusual stance of reading out many documents, which I usually orate verbally. Normally you have to give an oral presentation of your plea. You may read a few things or quote from manuscript. But that's not always the case, because many colleagues also write their plea and then they also read it. I have now read written documents that I wrote myself back then, which I submitted to the court and to the prosecutor's office at the end of 2023, which was somehow not considered at all. Because the 2 lay judges had no access to the files. They only know what is written in the 2 reading files. Well, in the reading files, for example, there is word of these agreements, but little information about its details. For example, they may not know that we had already formally declared the assignment at the time. The assignment would have been accepted at any time. With this declared assignment, the damage is actually compensated. The fact that it was sent to the court is ultimately another evidence and a proof that the defendant is willing to pay back the money as agreed. Otherwise he would have said to me, "Are you crazy? The assignment is not going out. You must be crazy." Exactly his money. But he didn't do that. And he didn't protest today when I read it. The claim has been dismissed and they would only have to accept it. Then they would have just communicated it to their lawyer colleagues. Justus Hoffmann and Andrea Fischer only to their fellow colleague Templin asking him to transfer Füllmich's 700,000 back into the accounts. End of story. It is also like from this chat traffic that I have read between Viviane Fischer and Justus Hoffmann, not clear that there had been any valid legal basis that Templin could oppose the 2. And you have to add, Templin himself is a third-party plaintiff, although he was not a member of the Corona Committee. And he has obviously through this complaint proven that the interests of the Corona Committee or this foreclosure commission were so important to have prompted a criminal complaint against Reiner Füllmich. And if all this is so important to him, then it should also be so important to him that he returns his illegally obtained money from the house sale back to his two colleagues for the Corona Committee accounts. So he shouldn't just keep it back because it's so funny that he obviously tricked the money or whatever, or negotiated particularly clever, as it was expressed in the chat. But even here the chamber of the state court that has all this as evidence, still rejected the evidence by its decisions. They further said they had agreed that they just assume without having to check it and therefore that they do not have to examine Mr. Marcel Templin as a witness since there is no assumption he got the money illegally. They just assume that Füllmich could have repaid the €700,000 from the sale of the house. The chamber agrees to that pure fantasy.
That's the odd part about the whole thing, because if they agree to it, then there's actually no harm perpetrated. That would close it. So I don't understand what they're doing here. To be honest, I don't.
Short question. You also alluded to the fact that the complainants claim they are the victims, but are actually the perpetrators. And you showed this on the basis of the chats between the complainants. Can you summarize the essence of these chats?
Well, the essence of the chats between plaintiff Dr. Hoffmann and Viviane Fischer is that she just asks how can it be that the Marcel Templin got this money, so the 1.15 million euros, I think. I've read it 1,000 times now, from the house sale from Reiner Füllmich and why he, as I mentioned, doesn't pay it to his colleagues, to the GOG, to the managers of the firm. And yes, he somehow said that he negotiated very cleverly and got a great deal. Why should he pay that back now? And Viviane Fischer then expects that this is somehow scandalous as it doesn't sit well with the donors at all. Ultimately, it would be somehow about the donors who are the duped ones. Also, all further investigative work would be prevented by that. And that seems to him somehow relatively irrelevant what Fischer thinks of it. So that's the essence of it. And that shows that he is not very bothered about the social fallout, the wealth or the work or education of the committee. So the chat is conducted very cavalier and casual with smileys and a lot of fluffing about.
The chat records are official. How did the chamber react to it to date, or was there none?
Well, Marcel Templin was not been examined in the witness box. He was listed in the program by the prosecutor for the main trial. We had repeatedly invited him as a witness and finally we had invited him as witness to the self-investigation. He then claimed that no money had been deposited or something. So in any case, he just didn't come and he couldn't. Everything else was frozen because we had a break since November 27th, otherwise we would have invited him.
Very simple. We can still file our evidence request via the police, but we already know what the outcome will look like. Because, I mean, so far we've been prevented to have plaintiff Templin examined and being heard. Then they'll do the same with evidence applications and pleas. Just the same. One could launch supportive evidence via the police, which could cause the investigation to be reopened after it had been closed in May 24. So I cannot see how the presiding judge would say he wants reopening of the case. I cannot see that. Okay, it has become method in this case to deny the petitions of the defense. So that's why I wouldn't want to deviate from the rule if I were the presiding judge.
Well, it was also emphasized earlier that that phase of the procedure had already been completed since May 24. All evidence by the defense was being blocked and we were being accused the indicted was delaying proceedings. Exactly, this is very unusual. And whether the examination of witness Templin would be equally doubtful. But if he was being heard, he could explain to us what right he claims to hold on to the money and does not pass it on to his colleagues holding entitlement, or why they in turn do not want to accept the funds. These are all such questions, including whether he still has the money. And why we are still looking for an explanations for the €600,000 of the loan since the clients all moved to the Füllmich office. What reason would he have to justify him holding the client's mandates when they had left Templin long ago? I have never experienced a client leaving me that I have the right to hold since I can't force it as it is the client right to do so. It is as if one has stopped buying once pint of milk at Tesco's changing to Waitrose and Tesco's coming after me trying to force my continued shopping of milk at their place. It is absurd and impossible. I had already read this out to the courts. Besides, having to read out the basic court rules is pretty boring to any audience.
On the other hand, I have to say I was outraged about the caution we received today, because we have a problem as follows. We are continuously in self-reading mode, so the courts shove everything into the files, which are kept away from the jury and the public.
The jury does view the material since they sit and ponder the case in a back room.
But most of their business is principally carefully conducted away from public scrutiny behind closed doors and not in an open hearing. This is not proper for conducting lawful business. We are principally bound by rule of law to conduct court hearings publicly. Everything has to be read out and discussed in court settings, open to public scrutiny. That they just disappear into the back rooms, the tabernacle of the courts, is extremely peculiar. It clearly shows the open disdain for having the public in attendance.
It is by my reckoning a faulty decision, including all the files that have to be read by the jury behind closed door. All our evidence has got to be made public demand. What I read out today were the documents which, indeed, the jury has no knowledge of. The jury has to carry the decision, at least I hope they are allowed to do so and are not just outvoted by the professional judges. We hope it is not a pious wish. The judges outnumber by 1 the jury of 2. The professional judges have the requisite knowledge and the jury doesn't. They are sitting there, even if only as drapery. They have a right to know the content of the files.
Final question. How do you assess the absences of the state prosecutors, Reiner and John?
I believe they simply had other duties today. I found it rather pleasing to see 2 young ladies instead, who looked very seriously, but at least they did not harass us during the breaks.
Have you finished your plea today, or are you continuing the proceeding?
No, I haven't finished. A plea does not only consist of endlessly reading out documents, which is not how I do it usually. In shorter cases one pleads for about 2 to 3 hours orally and standing up, which, as a rule, I normally do. I may have some notes I quote from memory and then a court decision follows. Here it is completely different. First of all, the extraordinary length of the written testimonials. Secondly, the long documents we have submitted were not known publicly before that entered the case before the opening of the main case. I wanted to show today that everything was already stated in the documents at the very early stage. It is incomprehensible that nothing was really being said about these clear submissions. Also, our steps taken against Marcel Templin and our suggestion to safeguard the money. The prosecutor's office did not pay any attention to this. We have no hint of any move in this direction. Last time I requested this, I was being asked what personal interest I had in knowing this as a counsel for the defense. It could be that this case was being sent to Berlin, which would be logical since Templin's office is in Berlin. Whether action was taken in this direction, we just do not know.
You do not know whether any investigation had been started on this since you filed the criminal complaint?
Exactly, no idea. It is probably not significant enough to the courts.
Did you inquire?
Yes, I have requested an answer several times in writing. But according to the Chamber, the criminal act has been proven due to the transmission of the money into the accounts and private expenditures undertaken with it.
Now Reiner Füllmich is being held in prison for 16 months. Will they continue holding him behind bars? Or could he be released on bail, or being electronically tagged with ankle brace?
The ankle brace solution was rejected outright a couple of weeks ago. Bail, as I suggested immediately after his arrest, was not considered. At that time, was also said that there are no tags here for remand prisoners in the state Lower Saxony. Reiner will definitely remain in custody for the entire length of the case being heard. Possibly then also the second main case directly following on from this one regarding the monthly payments. And then it just depends on how high the penalty will be, and whether he will be sentenced directly after that, under the supervision of the prison order. That's what the prosecutor's office also said.
When do proceedings continue?
Probably on the 17th.
Then it continues on the 17th. Thank you very much for the interview.